Hey everyone, Dustin here from lawatourside.com, where we provide real legal help when you really need it. And today I'm going to deep dive into the specific question of, can you sue your employer if they were negligent? So in a different video, I talked about how you're bound by the workers' compensation system. So what that means is in California workers' comp, it's what's called a no-fault system, meaning even if your employer committed no fault whatsoever, they are liable for your injuries sustained at work or caused by work. So what happened was a long time ago, the law had changed where it basically made employers immune from civil liability, meaning you can't sue your employer because you got injured at work. And because you can't sue your employer, that also means you can't get payment for all your pain and suffering, for lost wages in full, things like that. Civil lawsuit is designed to make you whole and complete as a person, and it gives you a lot more lucrative benefits in that realm. In workers' comp, there's a lot less benefits, and it can be a lot harder to get medical treatment and things like that, but you're stuck in this system if you were injured at work, even if your employer was negligent. So let's say that they had a floor and the floor was slippery and you walked and you slipped on the floor, and people have been complaining about things like that. That would be deemed employer negligence. They are not liable extra because they were negligent. On the flip side, let's say the employer did nothing wrong. Let's say you're working there and you trip and fall on yourself and you break your leg or something like that. The employer did nothing wrong, but because it's a no-fault system, you're still entitled to workers' compensation benefits. So because of that trade-off of fault versus no fault, it doesn't matter. If you get injured at work, you get injured at work, you're entitled to benefits. Now, if the employer did something really extravagant, such that it might rise to an OSHA violation, the California Occupational Safety Hazard violation, then you might be able to file what's called a serious and willful claim. It's an extra claim on top of your normal claim. That's as close as you're going to get to suing your employer in the workers' compensation system. But to be able to do that, it has to be a very high level of negligence. It has to be gross negligence, essentially, and there has to usually be a violation of some sort of safety standard. If you have OSHA come out and they do an investigation and find that the employer, in fact, had a violation of some sort of safety regulation, that helps a lot with a serious and willful claim. Things like that often happen if they have employees working at heights without safety harnesses, or they have them up in these machines or on a forklift pallet or something like that without any kind of safety. OSHA can come out and they can do an investigation and then fine the employer in those kinds of cases. Those would be, again, an extreme level of negligence, not your normal standard of negligence, like maybe they didn't clean the floor and didn't really violate any large or extreme safety standards. So to conclude, just because your employer is negligent doesn't mean you can file a civil lawsuit against them. There are benefits and also not so great benefits of that, but that's kind of the way it is right now. So thank you so much for watching that video. If this video helps you, please click the like button below and subscribe to our channel. Also, if you want a free consultation or for us to help you on your workers' comp case, please give us a call at the number below and we'll be more than happy to discuss it with you.